You're tuned in to The Andrew Lawton Show.
Let me bring into the show Christine Van Geyn, who is the litigation director for the Canadian Constitution Foundation, which has said this is a bill that will limit discourse. No two ways about it. Christine, good to talk to you. Thanks for coming on today.
Thanks for having me on, Andrew.
So we have a couple of things here that I think are very important, and one has been, I think, the most predictable discussion about this bill, even before it was introduced, and that is how is government going to define hate speech? And the bill does include a definition of it here, which, just for context, is, quote, the content of a communication that expresses detestation or vilification of an individual or group of individuals on the basis of a prohibited ground of discrimination, unquote. And that's, race, gender identity, all of these things that we know are protected grounds in the Canadian Human Rights Act. And it also adds to that it doesn't meet this threshold for detestation or vilification just because it, quote, discredits, humiliates, hurts, or offends, unquote. And I've seen a lot of people talk about this in the context of, it's, trying to make sure it's not just going after speech that has the potential to be offensive. But are these things really clearly defined from what we know about this bill now, as far as when something crosses that threshold from discrediting and humiliating to vilification?
I mean, all of these things are just inherently subjective. And that's the problem with trying to create a statutory definition for a subjective concept like hatred. And, there's a lot of existing case law that has dealt with the difference between these two notions, the detestation and vilification versus hurt feelings and things like that. But one of the things that is so notable about this bill is it's brought back the civil remedy, which means you can, as an individual, bring a claim to a tribunal about someone who has used what you believe is hate speech. So if the definition is as it is, which I think has a huge amount of subjectivity in it, you're asking the public at large, who can make use of this tribunal mechanism, to understand the real nuanced difference between what is and isn't hate speech under this statutory definition. And if you and I are struggling with it, and we are pretty deep into this stuff, I think your average Canadian is really not going to know the difference. You're going to have a lot of frivolous and disruptive claims brought under this new civil remedy.
Yes, and that was exactly what happened when the Section 13 1.0 was around. Prior to 2013, you had people that were using it. They were shopping complaints to the Canadian Tribunal and to provincial ones. They were going after columnists they didn't like, bloggers and authors. And in seeing this, the one glaring issue here, when you talk about the civil remedy, is that the threshold for a civil wrong in the eyes of the law is lower than it is for a criminal wrong. So the hate speech definition that we have in criminal law, which is very high by design as a threshold, is necessarily lower in this, is it not?
I believe it would have to be. I haven't reviewed the bill in detail, but it is a civil remedy, which would suggest a civil standard rather than a criminal standard. But that old remedy, this old civil remedy, Section 13 of the Canada Human Rights Act, was repealed for a reason. The reason was that the government of the day believed that remedy was being abused. It had been highly politicized, that the remedy was being used to target certain types of speech and not other types of speech based on sort of like a political correctness standard. And I think that there was a good reason to have removed that remedy. This government is bringing it back, proving once and again, and expanding its scope to now include all kinds of online content. So they're proving once and again that they are one of the most anti-speech, anti-expression, anti-technology governments we've ever seen in this country. And I think that this type of arrogance by this government on imposing their views about what Canadians should and should not be allowed to say and how they should communicate it, and creating even more government overreach on how to monitor it, Canadians should be very concerned.
I would agree, and we can talk about the subjectivity of fomenting detestation or vilification, but there's another word in there that was in the original Section 13 and is back, which is likely to foment detestation or vilification. And when you hear likely to do something, it brings up images of Minority Report to me and prosecuting people for things that haven't even taken place but might take place.
Yeah, so I think that that's another part of the problem is this vagueness standard in the law and the whole subjectivity. And there's also there's another portion on this that has even more to do with this sort of Minority Report aspect, which is this conditional. I forget what it's slipped. The word is slipping my mind now, but it relates to youth. But there are restrictions on conduct before they actually happen. I'm sorry, it's slipping my mind.
Oh, is this the peace bond section?
Yes, it's the peace bond. Yeah, it's the peace bond aspect, which is really troubling for a lot of civil libertarians. This notion of peace bonds, which restrict conduct as a condition of release for a criminal act. So. But this is something that a lot of civil liberties organizations have raised concerns over, this new peace bond, and this is something that's also included in the legislation.
Yeah, and just for context, so someone can go, if they're concerned about someone's speech, theoretically, to a court and apply to have a peace bond applied. And if you have one of these applied to you, I was looking through this section, you could have lawfully owned firearms taken away, you could be forced to do drug tests, you could be as well subjected to wearing a monitoring bracelet. So you have very real limitations of your freedom, and you're right, based on a crime or an offense for which you have not been convicted or perhaps even charged.
Yeah, so this is why there are a lot of concerns with peace bonds, like sort of generally, but in this particular text where it relates to expressive activity, it's seems like extreme government overreach. I apologize, the word slipped my mind. I don't know how that happened.
No, trust me, I try to get these things out of my mind as quickly as they can. So no judgment on that. I guess the question that I would ask you, and I know we're getting long ahead of ourselves here because a bill like this will not even be debated in Parliament before summer, and if there's an election, it completely goes away and would need to be reintroduced. But are things like this, in your view, likely to be struck down as unconstitutional, or is there enough of a wiggle room from reasonable limits and other forms in the jurisprudence that suggests something like this could actually be upheld?
Well, I certainly think it will be challenged, but I will say that the hate speech, the criminal hate speech laws have been upheld in this decision called Whatcott. And then there was a challenge to the previous Section 13, the civil remedy, which was also upheld. So I do think that this bill is different. It's more expansive. And I also think in the revised version of the bill, we're likely to see something related to takedown orders for platforms. That makes it different as well. That doesn't appear to be included in this bill, but I do think that is likely to come in perhaps a revised version of it that we may see later. But I think that there's going to be a big interest in challenging this legislation. And I will say that, I view hate speech as abhorrent. I view racism, homophobia, these things are abhorrent, and these are ideas that are nasty ideas that we should explain why they're nasty ideas. And if you have people just lurking on the internet, secretly sharing terrible ideas and concepts without confronting them and explaining why those notions are wrong, you'll never end up with a better society. Instead, you'll have a society that criminalizes teenagers for burning pride flags, and that's not a good direction for society.
Very well said. Christine Van Geyn, litigation director for the Canadian Constitution Foundation. Christine, thank you so much. Always a pleasure.
Thanks for having me on.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.